court, Your Honor. And she's been a lifelong resident of this area, Your Honor. She's never missed a court date, never been held in contempt of court, Your Honor. We believe, in hope of the reasonable bond will be $15,000 cash. Thank you.
All right. Detective, did you have a rebuttal or you just
have an active warrant for felony vandalism?
All right. Counsel, are you aware of that?
I'm not aware of that, Your Honor.
With that, detective, is that a hold also?
Yes.
All right. So I'll go ahead and set a bond, but keep in mind that
There's a hold.
right. So you may know, or you may let your counsel know if there's any other charge or something else is going on, but detective is indicating to the court that even when you post the bond, there may be another jurisdiction or another court that's looking for you based on some other charges. All right. You understand that? All right. And what I'll do, counsel, in the spirit of fairness, I'll keep it the same with your other client. It'll be a $15,000 surety bond. The court date will be Monday, 12th floor of the Justice Center at 9:45, and I am going to enter the not guilty on the misdemeanors. Okay.
Thank you, my child.
Take care. Derek Davis, 21 TRC 00422. This is a driving under the influence charge. And it looks like at this stage, the city and the defense attorney are requesting a continuance of the pretrial so that the body cam information can be obtained. Is that correct, counsel?
That's correct, Your Honor.
All right. Mr. Davis, you understand that?
Yep.
So I'm going to go ahead and reset this. For May 17th at 9:30 in the morning. And I'll give you a reminder in just a second. You can have a seat. All right. Lisa May. Okay. 21 CRB 00405, a disorderly conduct. And then we have, and that's from April 21st. And then we have a February 5th, 21 TRD 00737, driving under suspension, improper traveling down a one-way street, and no seatbelt. That is a traffic case. The disorderly conduct is a first-degree misdemeanor, which means you could get up to a $1,000 fine and 6 months in jail. But it looks like on that particular case, the city has amended it to a minor misdemeanor, which carries no jail time and a maximum fine of $150. And on the traffic case, that's also being amended to failing to display, which lowers your fine, doesn't carry any points or a suspension. So let me deal with the traffic first. On that traffic case that's being amended to the no point violation, how do you plead to that charge? Failing to display your license. All right. And then counsel, I believe there was a seatbelt also. All right. So the seatbelt is a $30 fine. The traveling down the one-way street will be dismissed and nollied. And the failing to display is a $200 fine plus costs. Now we're moving to 21 CRB 00405. That was the disorderly conduct. And counsel, I see you are standing to represent your client.
Your Honor, I apologize. In the traffic case, we would just note for the record she did provide insurance. We sent that to a prosecutor, and I think that was noted on the case sheet.
Yes, sir. Thank you very much. All right. So the disorderly conduct is alleging that this occurred on April 21st here in the city of East Cleveland in the hallway near the clerk's office. But the defense, or excuse me, the prosecutors amending this to a minor misdemeanor. Madam Prosecutor, can you make a record in that regard?
Yes, I'm not quite sure what initiated this. It seems that she came here anticipating being able to go to court. So I don't know if she was late because it was 10:30 and she was too late to come into court at that time, or she had missed a date on another day, but she was advised to go to the clerk's window, and she became extremely upset, and she started using profanity at the window, and there were approximately 15 people in the hallway, probably, just having had court waiting, and so they had to witness all of that. But since it was fairly minor, I'll give them on yesterday.
All right. Ms. Mabe, to that minor misdemeanor that's reduced from the first degree misdemeanor, how do you plead?
No, contest.
All right. So the no contest is a way to resolve the case. You're not admitting any guilt. Is there anything you'd like to tell me about it, or did you want to just get the case resolved? How do you want to handle it?
Yes, I do want to say something.
Okay.
I apologize. I was late that day. I was coming in for minor traffic. Sorry.
That's okay.
And I was late. I did apologize for that profusely and asked if I can just come in and get it over with. I just got over COVID. I don't have it anymore.
Okay.
But I was kind of irritated because I couldn't taste or smell anything for 30 days. And I'm not trying to make excuses, but that is okay. I want to apologize. I don't believe that I know that arguing is disorderly, but I was trying to explain to her that I got fired from my job because of COVID, and I am indigent right now because I have no income. I'm going to food banks right now. Hopefully that's going to change because I have several job interviews this week. Well, actually, going into next week, I have some job interviews. Today, I actually have one, but I'm hoping that's going to change and I'll be able to. I was trying to explain to her that I couldn't pay the $50, and then she said, "Well, you're not going to be seen because you're late today and you have to pay the $50 or you're not going to get another court date and you'll get a warrant." But that's really what the argument was about. And then it just got out of hand out of there. And she wasn't understanding I could not pay the $50 at that time. And then the officer came out and I was trying to explain to him, I talk loud. I'm just a loud person. Like, yes, I probably did swear, I'm going to be honest.
Okay.
I apologize. I have a bad mouth. I'm trying to work on that. So I apologize. I didn't mean to disrespect anyone. I didn't mean to be late either.
All right.
So I'm sorry.
Okay. So what I'm going to do is obviously I don't know exactly what happened, but of course just being in the building, I caught the tail end of it. So I sensed and was able to tell that you were pretty upset. I didn't ask what was going on. I didn't think it would get to this point. But like you said, I'm glad you apologized because maybe just the fact that you didn't calm down fast enough caused you to end up with a criminal charge, but it's reduced to a minor misdemeanor, so it won't be on your record. And so I have an option to give you a $150 fine. But honestly, for me, it's more so about, just getting the picture of how to move forward, so that when you're in this situation, whether it's my court or anyone's, that you just kind of think about, okay, last time I got in trouble and exactly zip it. That's the key. So it's not about the fine for me. It's more about the experience and what you gather going forward. So what's going to happen is, as opposed to a $150 fine, it'll be a $50 fine. So I'm gonna take off $100 plus costs. And then what we're going to do based on everything you mentioned to me, if you need time to pay, we'll work with you because I'm confident based on your position that you're going to go ahead and get a new job and everything is going to look up for you coming from here. So I'm glad you got it resolved and took responsibility, and we're not holding anything against you, and just, be blessed as you go forward. Okay. All right.
She did have one question. Her daughter actually posted the bond for her. The older daughter be getting the bond money back. It wasn't posted by.
So what we'll do is in that regard, keep in mind that once we do anything in regard to the bond and then the payment plan, you have to keep your payment plan arrangement because otherwise your license will be forfeited. All right. So you just go to clerk's room.
Right. Thank you.
All right. You're welcome. Colette Johnson, come on up. Whose name is it? Chloe. Remember, technically, if they put that on the record, I can't stand when they do that. Because we're not supposed to do it, but I hate when he do it. So, yeah, I'm gonna put it here. All right. In 21 CRB 00314, it's a cruelty to animals charge from August 22nd of 2021. And it looks like specifically the complaint is alleging that on or about June 27th, 2019, they're naming you as a person who did confine or who was the custodian or caretaker of a companion animal, or 2 or more dogs, negligently impounded or confined the companion without affording it the impoundment or confinement with access to shelter from heat, cold, wind, rain, snow, or excessive direct sunlight, where it is reasonably expected that the companion animal would die or experience unnecessary or unjustifiable pain or suffering as a result or due to the lack of adequate shelter. And that is charged as a misdemeanor of the 2nd degree. You spoke with counsel, correct? And then there's a second charge alleging that on the same date, June 27th, on or about that date, you did negligently torture, torment, or commit an act of cruelty against the companion animal. Counsel, on behalf of Ms. Johnson, how are we proceeding today?
Your Honor, at this time, to enter a plea of not guilty, we ask this matter be set for pretrial.
All right, so we're going to enter that not guilty plea, set the pretrial date, Bailiff Sanders. That will be May 20th at 9:30 a.m. Thank you. We'll give you a reminder before you leave. Take care. Where's my stuff? Yes, she may. Okay. All right. Is that Mr. Thomas?
Yes.
Lavelle Thomas, come on up. 21 CRB 00312, June 27, 2019, cruelty to animal charges. You spoke with counsel also, correct, counsel?
Yes.
All right, and Mr. Thomas. Counsel, at this time, are you going to enter a plea of not guilty?
Yes, Your Honor.
And would you waive the reading of the complaint?
Yes, Your
All
Honor.
right. So basically, Mr. Thomas, what that means is based on the fact that you spoke with the lawyer and we understand that you know what the charges are and you've heard them, I'm not going to have to read them on the record. And we'll maintain that not guilty. And I'll also see you on May 20th at 9:30 a.m. We'll give you that reminder. Thank you, Ms. Ivory. All right, Felicia Hainsworth. 21 CRB 00315, Ms. Hainsworth, this is from December 24th, 2020, alleging a cruelty to animals. And they're stating that you did negligently impound or confine a companion animal without offering it proper shelter from heat, cold, wind, rain, or snow, or excessive direct sunlight. And then count 2 is alleging the same dates on or about December 24th through 25th. There's an additional charge of negligently depriving the animal with the necessary sustenance or confining the animal without supplying it during the confinement with sufficient qualities or quantities of food, water, and also there is a reasonable expectation that based on that negligence that the animal would experience suffering, pain, or even death. And counsel, you're maintaining not guilty for Ms. Hainsworth at this time?
That's correct, Your Honor.
And we're going to set your pretrial for May 27th. Is that your understanding? All right, we'll see you back on that date at 9:30 a.m. All right, so is it? All right, so gentlemen, couple things. I'm Judge Dawson. I want to make sure you understand what your rights are. First of all, you have a right to an attorney, which we're going to make sure you get a chance to speak with the defense attorney here today, or you can hire your own attorney. You also have a right to remain silent, which means when I call your name and you come to that microphone, you don't have to say anything at all, at which point I will maintain that you're not guilty of the charges. And then you also have a right to a full hearing. If it's a misdemeanor charge where you're facing up to a $1,000 fine and 6 months in jail, that hearing is here in the form of a trial. If you are charged with a felony, you have a right to what's called a probable cause hearing. The probable cause hearing is where the city has to indicate that a felony was committed in the city and that you are probably caused or at least the probable cause of it. And that does not indicate that you're guilty. Instead, what the city is trying to indicate is that the felony charge cannot be heard in the city of East Cleveland because this is a misdemeanor court. So that's basically what the probable cause hearing is about. But after you speak with your attorney, you can decide to waive that hearing if you understand the charges against you and understand, most importantly, that you're still not guilty, even though you allow the case to be sent to the county. With that, I will set a bond and a court date so that you know where you're going and how after you leave here. All right, so I'm going to give you a chance to speak with your attorneys and we'll go from there. Just from a procedural standpoint, well, my best not to pass out dogs when I'm talking because immediately they all look down. Yeah, I mean, I was talking to the wall at that point.
That's somebody different. Huh?
Person I hear?
No.
Oh, it's Max. Thank you, sir.
So which one am I calling? All right. Oh, it was another one. Yeah, I put it in there, and I put specifically to her. Anthony Battle. Is Mr. Battle? So we have two. We have Battle and Saeed. All right. Hey, we made it through. I'm never worried that we won't make it through. This would be hectic as heck. And you know I'm coming up with a specific program for you. You're over the backpack. Seriously.
Yeah, I'm sorry. You have to wait for the phone to get done.
Oh, no. No, we don't have the other people in yet. So. Is Battle out there or something like that? Oh, Battle's not here. Okay. 21 CRB 00420. Anthony Battle. Anthony Battle is not present. That's from April 8th, 2021. And then I also have 21 CBH 00317 filed April 28th. And this is the Cuyahoga County Animal Shelter versus Anthony Battle. Mr. Battle is not present. And we do have someone who is present from Cuyahoga County. Can you state your name for the record? As best we can with the mask and all that good stuff. All right. Thank you, sir. And can you just give me on the record what's going on in regard to the service of the complaint?
It's for a dangerous dog.
Okay.
The dog got out and actually hit one of the county employees while they were trying to work on the street. And it inflicted about 3 bites to the leg and to the upper back.
Okay. Where's the dog now?
In his possession.
In your possession?
No.
Still in the defendant's possession? Okay. And the defendant he was served with his court date by you, or was it by this court?
By me.
Okay. All right. And this was his first appearance?
Yep.
And counsel, obviously you haven't spoken with him. Madam Prosecutor, how are we moving today? What's your desire? Are you helping out? Or I'm just wondering. So we have, because normally in a regular criminal case, obviously we would reset it for another pretrial, give him a chance to be here and or issue a warrant for his arrest. Is there any other way that you would prefer this being handled in regard to the animal being involved and it being the
Well,
the animal shelter?
I was unaware that our office was going to be handling this, but yeah, we would request a warrant considering the fact that there were bites involved to a person. And generally, I think the animal is confiscated, but I don't know
Right.
why that didn't happen.
Yeah, because most times,
The police are not involved or how.
yeah, because a lot of times when you get here, you guys already have the animal.
Typically, that's the APL.
Oh, okay.
Yes, 2 different.
All right. See, I love the fact that with all of these, I'm constantly learning every single time. So the APL, normally they grab the animal
Correct.
or the dog.
We don't.
You don't. Okay.
The owner can keep the animal and have him in 10-day quarantine, which he did.
Okay.
And then after that, depending on how bad the bites were, which they were pretty severe, that's what we're moving for dangerous dog.
Okay. So are you okay with me resetting this for another hearing to give him a chance to get here? But he did receive the first notice from you, and it looks like he also received something from this court. And when you spoke with him, was he receptive?
He was compliant with everything that he understood. The dog got out and it bit somebody.
Okay.
And he was taking responsibility 100%.
All right. So what I'm going to do, only reason I ask that is because I don't want to waste your time, but at the same time, I would prefer to send him a strong notice as opposed to a warrant so he doesn't get arrested. So let me set this for 2 weeks out. If he is not present, then all bets are off and there'll be a warrant and we'll notify you once we have him downstairs. So we'll reset this for the 13th of May at 9:30. Thank you for your patience. All right. So let me do this. And then now we have 21. Counsel, did you get a chance to speak with your client?
Yes, I did.
Are-
I did this morning, Your Honor.
Are you ready?
I am ready.
Okay. So, counsel, I don't know if you spoke with the city, but we'll set the prelim for Monday. Are you okay with it? All right. So, Jamie Sowell, come on up. We have 21 TRD 02318, which is a traffic case, driving under suspension, disobeying a traffic control device, and obstructed license from April 27th. And then we also have 21 CRA 00422, obstruction of official business and failure to comply with an officer's order. The obstruction of official business is a felony of the 3rd degree, 9 to 36 months in prison and a $10,000 fine, where they are alleging that on or about April 27th, Mr. Sowell did knowingly flee from police in a motor vehicle while having entered a felony warrant for your arrest. I'm just reading the complaint. And then there's failure to comply with an officer's order, also a felony of the 3rd degree, 9 to 36 months and a $10,000 fine. Again, based on the allegation that on April 27th, there was a fleeing from police officers while having a felony warrant for your arrest. Counsel, in regard to the preliminary hearing, it looks like you're requesting one, correct?
I am, Your Honor.
All right. So we're going to set that for Monday morning.
And Your Honor, I can just be heard briefly.
Yes.
I think the probable cause, what you just read, that doesn't state a violation of a felony law. There is no element as far as if you have a felony warrant and then there's a fleeing and eluding. I think that the statute talks about if you flee immediately after committing a felony offense. And there was no felony offense committed at that time. As the court pointed out, there's a driving under suspension. So I believe it's a misdemeanor fleeing and eluding, not a felony.
Okay. And so, and just because you're making a record, which I appreciate, and for the clarity, it looks like there's the obstruction F3 with the language that you spoke to, and then there's also a failure to comply with police order. Would that also be the same argument that you're making?
It is, Your Honor.
Okay.
That would then be a misdemeanor as well.
Okay.
And they seem to be duplications of each other.
Okay.
And I'm not really sure. And I know that when I spoke to Mr. Sowell, he indicated that it was initially filed as a misdemeanor, and then they somehow, there is a warrant for him. I'm not going to dispute that.
Okay. Current warrant. Okay.
Out of Cleveland. He hasn't been indicted. It's just the registered warrant that they issued. So, but I don't think, and I've read the statute, I looked at the statute again this morning, there is no element or subsection that says if you have a felony warrant that somehow it becomes a felony fleeing and eluding. It's a misdemeanor fleeing and eluding.
Okay.
So the reason I bring that up, not to get ahead of myself a little bit with the preliminary hearing, just so the court's aware of that and making my request for bond, Your Honor.
All right. Thank you, sir. Detective, the bond request from the city. I kind of know what
$100,000.
Okay.
Can I say something?
Yeah, absolutely. I was going to ask you if you wanted to give me more.
This pursuit lasted more than 10 minutes. It reached speeds of 75 miles an hour on Euclid Avenue, 75 miles an hour on 152nd Street, 95 miles an hour in St. Clair, ultimately resulting in him crashing into a pole and taking out a street sign. We just had an officer nearly come within a telephone pole of getting killed just several weeks ago. Again, pursuing a vehicle at approximately 75 miles per hour. And he told a police cruiser the pursuits need to stop as far as people running from the police. And it's creating a risk of physical harm, serious physical harm to the general public, the officer chasing him, and the person who's up.
Okay. Thank you. Counsel, for your client.
Your Honor, again, I believe this is a misdemeanor offense. We would ask the court that this is really traffic offenses, and I understand what the sergeant is saying. The issue, I think, it's born on both sides, to be honest with you. I think that when the pursuit begins, and I'm not familiar with it, I'm not conceding there is a pursuit or anything, but Mr. Sowell, he is employed. He was working full-time prior to the pandemic. He is picked up a painting job. He's working at a temporary agency. He's contacted me. I've represented Mr. Sowell for years. He will always show up to court, Your Honor. I think that $100,000 bond is excessive to ensure his appearance. We would submit perhaps a $2,500 or a $5,000 bond would be appropriate in light of these facts and these circumstances, Your Honor.
All right. So, counsel, what I'll do is a couple things. Is you're correct in the fact that the most important, well, the main factor in regard to the bond is making sure that he appears to court, and then also the safety issue, just making sure that the community is safe. We are going to set the preliminary hearing for Monday at 9:30. So hopefully everyone's ready for that. And Mr. Sowell, I will reduce the bond. But keep in mind, one of the things when we consider bonds is that and you're not guilty of it right now, but the fleeing and eluding and the chases are a high concern to me, not only for your safety, because you could be injured or killed, but then other people. And just generally speaking, obviously you can imagine I move through the city all the time and I see these things occur. So it's really something that the court has been very serious about, trying to get the message that has to stop. So what I'll do, as opposed to a $100,000 bond, counsel, won't be as low as you're requesting, but I'll reduce it to $75,000. So I'll take $25,000 off and let it surety or 10% for that. But otherwise, if you're not able to make the bond, Mr. Sowell, by Monday, counsel, I will entertain reducing it even further at that point.
All right.
All right. Thank you. Okay. Oh, yeah. I see what you're saying. All right. Ms. Saheed, come on up. Ms. Saheed's case is 21 CRB 00309, and this is dated March 26, 2021, cruelty to a companion animal. And then we have 21 CRB 00311, March 20th, 2020, also a cruelty to animals. Counsel, Mr. Humphrey, I know did you have a chance to speak with Ms. Saheed? Counsel, how are we proceeding today?
Your Honor, at this time, with regards to the criminal case, we're entering a plea of not guilty and asking that matter be set for pre-trial. I did note that there is another portion of this, which is essentially a request for civil forfeiture of the animal, and my criminal client will be representing herself, and that is I don't represent people in civil cases.
All right. So the other charge is filed as a CRB, but is it civil in nature?
Correct. It is a civil forfeiture proceeding.
And which one would that be? The one dated the 20th or the 26th? Or I guess we can figure that out as we go.
It's the one with the notice of seizure inside of it.
Okay, the notice of impound. Okay. All right. So we're gonna reset the other one for the pretrial. Is there a certain date that you two came up with? Because I know you're.
The 20th and 27th are the dates assigned to the other APL cases, so either one of those work.
All right. Let's set it for 27th. Okay. So May 27th. Okay.
I have had some discussions this morning with Ms. Saeed as well as her children regarding the civil forfeiture proceeding of this, and trying to determine what decision they would like to make as to surrendering the cat or even claiming ownership of it, because there is some question as to whether or not it is her cat at all. And I believe those discussions are still ongoing between Ms. Saeed and her children, so I'm not quite sure where we ended up.
Okay. All right, Ms. Saheed. So at this point, I guess one of the questions is, one, I believe, are you claiming ownership or do you have ownership? I know on the record before you mentioned that you discovered the cat. And then also the question with the charges being that the cat is suffering from medical issues at this time. Are you willing to turn the cat over to the APL at this time? I believe those are the two questions, correct, Ms. Saheed?
I don't have any problem with them keeping the cat. I just had some concerns and some compromise I would like to make with them. The concern was, I do know that from me going to the APL one day that they actually kill cats if they don't adopt them within 2 weeks, and that's what a worker had told me. Okay, so I was concerned about that.
Okay, so let me stop right there. With the seizure that you're requesting right now, there isn't any determination that the animal will be.
Correct. The APL is a no-kill facility. Your
Okay.
Honor. They do not kill animals for space or for time. They kill animals as long as they are medically treatable, and they have a very high adoption rate. This cat is in no way, shape, or form in danger of euthanasia.
Okay, so
That's contrary to what I'm.
okay, but now on the record that they've stated that, does that answers that question for you?
I'm just hoping that they be at their word. And,
Okay.
The second part is, okay, they pretty much put me up under emotional distress from them taking, because my cats are emotional support animals. Okay, they took them off my porch without even questioning me about them or even asking me the circumstances about the cat.
Okay.
Okay, so I feel like, okay, well, they can do that to my other cats. My other cats be around, they probably come and do the same thing to them. So I would feel harassed. I really would feel seriously harassed. I don't want them harassing me and doing that to my cats. Some of my cats don't have collars. Sometimes they run off, before I try to put a collar on, they may run off without a collar, so there's a lot, and then there's other people's animals out there that could be collarless, so it'll be for them to pick up a cat because it's collarless is really, it's not, really taking away someone's possible pet. Okay, so I don't want them harassing me. I want them to stop harassing me, and because they came unannounced as well. They had no reason for being there, and then all of a sudden, bam, here I got a problem. So I kind of missed the cat, So I was trying to help the cat. So the only thing I asked is if I can be able to see the cat eye to eye. And a lot of people wouldn't understand that, but I would like to see the cat eye to eye and have the leniency that they would give anybody who would want to adopt a cat at this time. And that's all I asked. If they can't do that, then I would like to talk to them.
Okay.
Your Honor, the APL has offered Ms. Saeed a virtual visit with the cat via video, which is how all adoptions are being conducted during COVID. We are not doing in-person adoptions at the APL. That was offered to Ms. Saeed.
Okay.
We also do not pick up stray cats. The APL solely focuses on neglect and cruelty. So if there are city animal control officers who are picking up cats, that is not the APL.
Okay. Do you have the cat now?
Yes.
Okay. All right. So, Ms. Saeed, let's do this. So, there are two issues right now. The court hearing the justification of your cat being in their possession now, the APL's possession. That's what we're doing right now. The other issue as to whether or not you should be criminally liable for any injuries or neglect to the cat, that's pushed off. So we're not dealing with that. So let me do this so that we all respect each other's time and your emotions and everything involved. I will acknowledge that the APL has the cat now. I will also acknowledge that it's been my experience, because I am learning, these cases are coming, that had it not been a COVID situation, the visitation would be different. But with COVID, I understand that things are changing all throughout our county as far as visitation and things like that. And I will make a record that there was an indication that your cat is not in jeopardy of being killed or put down or put to sleep in any way, but medically restored, and then adoption would be a possibility. And I think those are the things that you're really concerned about, the life of the cat as well as the cat's health. So I will acknowledge that all of that's been presented correctly to me today. But the issue that stands, whether or not you've done anything wrong or should be charged, that'll be moved to May. And I think you made a good record. I mean, as far as making a record and them understanding how you feel about their presence at your home and all of that. So you were able to make that record. And I understand that you wanted to do that. So I think that's been accomplished also. Anything else that you don't understand?
I might have something going on the 27th, but I have to check.
So if you do, if you could at least give us the courtesy of letting us know, they're going to be here anyway. So if we need to reset it after that, we'll do that. But somehow let the court know so that we can reach out to them and let them know that that day you won't be present.
And my other concern is at some point they, even though they have the virtual thing, for them to adopt a cat or adopt an animal, they would have to come to pick the cat up anyway. So at some point they have some, be able to see the animal, and then also they have to make sure that that animal is is comfortable with the new owners. So I know that at some point they have to have some kind of interaction there with the animal. So I want the same respect that they would give someone who's willing to adopt the animal to be able to see that cat in eye to eye.
As I explained, you're doing virtual adoptions. Nobody is coming into the animal facility. The adopters
Oh, no, I'm
leave the
I'm
cats via video, Miss Said, and then the animal is brought outside to them in a carrier. We are not going to bring a cat outside in a carrier that is going to get loose so that you can interact with it. You will have a virtual visit if you so desire.
And just so that I'm clear in what I'm hearing is that even with an adoption, it's done pretty much the same way virtually until the day they come to pick up the cat, and then there's the handoff. So unfortunately, even with that, it seems that because of COVID, there isn't the normal handling and visitation, even for those who are adopting any of the animals that the APL has.
And I don't expect to go inside. I mean, I can understand not going inside.
Well, let's.
The cat is not gonna run off, but I mean, of course they can handle that. You know, the same way that I'm just asking the same way they would handle the cat that they would give allow someone who's adopted. I want the same respect.
Okay, and all right, so
and the same situation they would do with anybody else in this country.
Okay. Understand. And
virtual is not just, I need to see the cat eye.
now I know were there any questions that you had? Because I know you were here before, and I just want to make sure everybody's on the same page as to how we're proceeding.
Yes, for this civil case, if she doesn't make a decision today, can it be postponed?
So what happens is technically they're in possession of the cat right now. And my part in that today is basically based on the information presented to me, agreeing that that is a correct or lawful or appropriate possession, which based on everything that I have, I understand that it is. So I'm not sure if there's a need to continue this particular hearing. The one that's really of concern is the next one where there are the criminal charges. And even at that point, and I'm sure counsel will have other discussions to see where the cat is as far as rehabilitation, and then whether or not there's a discussion about return. I don't want to get ahead of myself, but maybe returning the cat or the adoption. I mean, so a lot of things can happen on that next hearing, but today's hearing was just for me to understand why the animal is in their possession and whether or not that is appropriate at this point. And because they are able to provide medical attention and everything else, we're normally leaning on that side just so that the animal can be rehabilitated to a good health.
Correct. This has been continued once previously.
I understand. Yep.
We conducted it for 10 days. So this is your continuing
Yep.
the site. Also, the court, assuming probable cause has been found, would need to assign a care bond if she does not pay or decide to surrender that cat, or if she is planning on claiming ownership, which again, we've not established that she is or is not claiming ownership. Assuming she does that, the court would then need to assign a care bond, which is the $450 a month for the cat to remain in the possession of the APL while the criminal charges are pending.
So, and that's another thing that's important to understand for everyone is that when these cases get to that point and an animal is taken and being cared for, it does become a financial issue at that point. They don't provide the medical care or the accommodations for free. So the hearings that we have and making sure that we're looking out for our best interest and the animal's best interest, it does begin to become a financial issue. I just want to make sure that's clear. And the reason that that's important, I mean, we've had all types of cases from, people who have spent a lot of money for their animals, and there's, a big concern. So the financial issue is not a big deal. Then we've had it all the way to the point where someone maybe just recently found an animal and fell in love with the animal. And then at that point, the same question arises. It becomes more than just, I love this animal. At this point, it becomes a financial issue. So that has to be considered also. Not necessarily is it worth it, but just generally speaking, that has to be considered, because they're also requesting me to put a monetary value on the fact that they are going to be housing this cat while these proceedings are going on. They're not doing it for free. Ms. Saeed.
I feel it's a really cruel and unusual punishment for them to be charged.
Well, I can understand it, but I don't want us to go back and forth, unfortunately, and I think that's why attorneys involved. There are statutes, there are laws on the book that allow them to do what they're doing. And until, maybe at a certain point that's taken up with legislators and or, the Supreme Court and things like that, that's where it is right now, that if they, for whatever reason, I'm not sure how they come to the attention of certain situations, but when they arrive on a scene and they're able to determine that an animal is not well and not being taken care of, it's their obligation at that point, based on their oaths, to get involved. So whether we think it's fair or not, that's just how it happens.
Well, they didn't have problems with, because the cat was not, the cat, just by looking at him, was not sick. Just looking at him, you could tell he was sick. Okay, my daughter could witness to that. When, based on the pictures, the pictures looked totally different from when I
Well, let me stop there, because again, we're going to have another hearing. The question, the point I think I need to drive home now is that this is about to, at this point, it's going to be a cost to this. And I think I need to make that very clear, only because the law provides it. That cost, that's not going to East Cleveland. It's not going to the court. It's the APL's charge based on them housing and caring for your cat while this litigation is going on. So I just need to make sure you understand that part of it. Now, I will say this, again, I'm just trying to, be as fair and, neutral as possible. But once we come back and counsel is involved on the other end, all of these things that he knows and he's hearing, those are negotiation points at that point. You know what I mean? Maybe there's a way to resolve this, that one, that maybe it's not that expensive, or maybe there's a surrendering of the cat, or maybe your cat has been adopted by someone else. I mean, there are other ways to resolve it, but I think just for clarity, so that there's no surprise, one, they're establishing to me why they took the cat. And I think we even made a little bit of a record the last time we were here. And then two, that they're asking the court to acknowledge that it's not a free service that they provide, and that there has to be a bond, or there's going to be a financial cost to this for you as we continue with this case. I just want to make sure you understand that.
Yeah, they took them off my porch without asking me any circumstances. The cat did not look, appear to be sick.
Okay.
And so they had no proper cause. That's all I requested. What I told them earlier.
Okay. So we'll establish the bond at this point. We'll reset the hearing, and then counsel, maybe at the next hearing, all of these things can be tools that you use to get the case resolved. So we're coming back on May 27th, correct? And that's $450.
You would need to choose a date. The bond would have to be paid by. I would note that this cat has been in the APL's custody for a month now. So technically, the first 30-day bond is due.
Yes, ma'am.
So you say you established a bond for her to pay $450 by which day?
Well, that's what they're asking me at this point. So what I could do, I was going to make a statement, but prior to that, if there's something that you would like to say in regard to that, they're basically saying it's $450 a month. The first 30 days have passed. Are you stating a date that you can pay that, or only because before I can say anything, well, I was gonna.
I would like to say I take care of her financial affairs.
So let me do this. What I would prefer to do, just based on what I have here, I'm going to establish that the bond is $450. Because I believe that this case will be resolved when counsel is involved at the next hearing. What I'm going to do is note that the toll, or at least the $450, is established at this point. And understanding that Ms. Saeed is not necessarily in the financial position right now to handle it today. Am I correct on that?
Yes.
All right.
I really prefer for a stray cat for her not to.
So what I'd like to do is I will allow the establishment of the bond to happen now, but I will stay the payment of it until at least we get this second pretrial taken care of. So you understand what I'm doing? I know there may be.
Then though, is it's a month away, so at that point she's going to owe $900.
Right, because I'm not sure she can pay the $450 at all. That's right.
That's why we've tried to seek a surrender here, so that she can have the video arrangement, and then there's no bills at all.
Right. And I think at some point, that's why I'm hoping when counsel gets involved, maybe when we have the criminal case, you can help with the discussions in that regard. But based on what I understand, Ms. Saeed is not able to pay that $450 today or next month or any month at this point. I mean, I'll establish it because I know I should, but I think, you know, actually executing that is going to be a difficult situation no matter when we do it. So I'm just trying to be as fair as possible, understanding that she can't pay it today. I will note that technically the bill will be continuing to toll. You understand, if this case went on for a year, you know, they're going to present at the end of the year, here's our bill. This is what's due. So at some point we have to address it. And we will address it fairly when we can, but I think it's important to know now that that's what they're requesting as the bond. I'm going to acknowledge that that is a fair bond at this point. And then we're going to have to figure out payment and all that stuff at some point.
Got a question, Judge?
Yes.
Okay, if the pictures are showing contrary to what I last observed, then how could that be probable cause?
So I think once, because this case is tied to another case, say for instance, you're charged with a criminal charge of neglect, right? So, and I'm going to conclude with this. That way we can just, you know, move forward. If on that next court date, if counsel counsel was able to show, prove, or discuss that there were no injuries at all, and this is a hoax and they shouldn't have even bothered you, then of course at that point everything should be discussed. Because if there's a negotiation or a reduction to there were no injuries, this cat is perfectly fine, why are we even here? Then of course the court would then have the power to you know, or I would assert the power unless I was overruled by a higher court to say that you shouldn't owe any money in the first place because it never should have happened. But we're not there at this point. At this point, there was a presentation to the court on at least now 2 occasions as to the injuries that the cat had suffered. And I believe there was even, I'm sorry?
That's a different case.
2 cats?
Yeah.
There are 2 cats.
2 cats, okay. All right. So yeah, and do you have possession of both?
The first cat has been adopted out. That one was for.
Okay, all right. So do we have any issues with that one
No,
financially or
that
nothing like that?
one-
Okay.
I have issues.
Okay. All right. So I understand this is going to be a challenge for us to get resolved, but we will get it resolved. And at this point, Ms. Sahi, just the last question, because you mentioned adoption. Would you be against if there was an adoption of the cat that they have now? If that was to happen?
I wouldn't have anything against.
And if that happened, that would.
If they asked me, if they would have approached me with, hey, what's wrong with this cat? Is it yours? And why has he got scratches on him? You know, but it was scabs at that point. If they would have said that and they would ask me, you want to take it, I would have willingly gave them the cat.
And just, is the cat in the condition to be adopted at this point? I mean,
No, it's still being treated right now.
okay. And is there an estimate on how long that'll be? I'm just curious.
I have to check with clinic staff.
Okay. So maybe that'll happen prior to May 27th, but then maybe
So
not.
we
That's
can't
kind of
do
aggressive.
that unless she surrenders the cat.
All right.
That's why
So are you, because you're willing to allow an adoption, are you willing now to surrender the cat? That's an option.
I was willing to allow him to be adopted, but I just wanted to see the cat. You know,
So,
I just requested that same respect that anyone who wants to adopt a cat to be able to see the cat eye to eye, you know, and that's something that a lot of people wouldn't understand. So
right, and I understand it, but then I think, do you understand what they're saying in regard to that? That even if someone,
you know, the authority or that,
well,
but I just feel like that's only humane.
well, see, all I can,
like that.
well, here's the deal. All I can go off on is what they present. For instance, if you were to hire an investigator and we found out that they were running people in there all day and all night for visitation, then you would have an issue. They've stood up here under oath and indicated that, hey, we're not doing any type of visitation other than virtual and other than the pickup. So when you say you want the same rights, they're saying that you're going to get the exact same thing. And we have nothing else to go on unless there was something else presented, like some, you know, I mean, I'm not even trying to be funny, a secret camera that was showing that this stuff was going on, but your rights were being violated. But right now they're saying they will afford you the virtual visitation. And then the cat will be adopted. So let's get, but I think this is important.
This site, and I would like to be clear also.
Okay.
We are doing this as a courtesy because we do not allow criminal defendants to visit with animals ever.
And keep that in mind. So what she means by that is your criminal case isn't resolved where there are allegations that you were cruel to the cat. Now you're going to fight that, but again, so you understand what they're saying in that regard. So my question is, so that we can maybe even move beyond a financial issue later on, are you willing to allow or surrender the cat so that when the cat is rehabilitated, it can be adopted? Are you willing to do that now, today?
I don't mind the cat being adopted.
Okay.
I just want to see the cat eye to eye.
But you understand, it's just the virtual at this point. There are no eye to eyes.
Okay, well, if they allow someone to pick up, the other animal, it's just that I would do the same thing. I just won't be receiving it. You know what I mean? I would see. Okay. When the criminal case is resolved, because I'm innocent, then I want to be able to see the cat again.
Well, it's possible that at that point the cat may be adopted. So I mean,
before it gets adopted, or after, or we still have that right.
Okay,
so we will have the surrender form.
I have a surrender form. I've noted that she is to be given a video visit with the cat within 7 days. So if you would like to sign that, the cat can then be adopted out. You would not be responsible for the cost of caring for that cat, including its veterinary bills.
I think that's the best option right now.
So I need to adjust my comfort level to do that.
Well, let me ask you this.
This is a courtesy that I asked for you.
And what I can say, I understand that, it's, time is ticking, but this is important to everybody. I do have the felony cases. If you want to sit down for a moment, if that's enough time to adjust and speak with your daughter, or because if we continue it to another date, that's when they're talking about the financial part of it being.
They're willing to waive all of the money you already owe for this cat. They're willing to waive all of it. So for the month of boarding it's had, and for all of the vet care it's already had, they will waive that. They will not ask for you to pay it back if you surrender the cat. The cat will find its home
I'll
through the
surrender
appeal.
with a clause.
There is a clause here that you will
And
be given the visit.
I would write my.
Well, what's the clause, Ms. Sahi, so that they?
Exactly what I said. I'd be able to.
Well, yeah, you would have the virtual visit within 7 days. That's what they're offering.
That's what I've
But
written.
that's not resolving the part of the issue for me. Just the virtual visit.
Mhm.
I mean, what would the cat get out of a virtual visit?
The
Nothing.
cat will be able to see you, and you will be able to see the cat.
I've had many cats. I've shown videos, and they don't really pay attention to that. So,
You can get a picture of it, a screenshot of you and the cat.
Yeah.
There is, I did write it in there, so that you'll be given a video visit within 7 days.
When you write the clause on there, it's not guaranteed that you would get it because it has to be an agreement. I said
I said if I can, if they can do it,
No, it's gonna take a while.
Right.
Okay, your cat's going to be forfeited, you understand, and then we're going to ask for the money to be paid.
So you're gonna be charged for the money. No, there's no reason to put the clause on there.
Well, I did write the clause in here.
For the visitation.
And then the extra one, she was requesting to write on there about the in-person.
Okay, yeah, we can't do it in person. That's not, unfortunately.
will you allow people who adopt the animals to,
Well, just so you know, they allowed them to come pick the animal up, but that's not a visitation. No, they've already adopted. That's not a visitation. That's a pickup. So they do allow that, but
okay, so but then they are able to see for however long.
yeah, only because they're picking it up.
That's minus that is that I wouldn't be actually.
Correct. We're not going to bring a cat out into a parking lot.
Yeah, they don't do visitations like that at this point.
This is a dangerous situation for a cat.
They were wrong for taking them off my porch and without asking me something like that. I know I don't want to kind of extend this any longer, but I'm gonna add my clause on there.
But you understand your clause may it may void the contract that you're signing, because if they don't agree, well, if they don't agree to it, you can't put a clause in that they haven't agreed to. They won't sign that. So I guess what's going to happen, and I think one of the big things I would like to avoid, I understand everything emotional and all, but I also like to look at it from a financial standpoint. I think if we walk out of here today without resolving this case, the only thing to keep in mind is that we're looking at now money being involved that you're going to owe, and there may be a judgment against you, whether it's collectible or not. That's something that they could pursue. So I think that's something to keep in mind. And I know your daughter has additional information, just in regard to what that could mean. And I don't necessarily want to put it on the record, but I think, we should really consider getting the case resolved today if the only issue is a virtual versus in-person visit.
Can I make one more statement? Okay.
Well, I'd rather not have a statement. I want this to be over for we're done for today. Either we're done with you walking out on a lot of money, or we're done with you not, and we're just coming back on the 27th because they're going to pursue the bond. That's all. I mean, I just want to, because I know the other issues, but the only thing today is whether or not how we're going to get this resolved today in regard to the bond and or surrendering of the cat.
It was just real quick statement.
Okay.
AP, I've been down to APL and I've been looking at the website. They have 90. This appears as if 90% of the animals that they have are offspring of my cats. So they've been pretty much, non-profit, properly owned by cats. And I say that because I know them when I see them, because I had a unique strain of a cat.
Okay.
Since I was 7 years old and grew up with them, I had a lot of cats, and some of them my mom had shown towards Hill sometimes. They were beautiful cats. So. And I'm looking at, I took a couple of screenshots of them, and they have a lot of them.
Okay.
So basically, I'm not. They're getting money, $25, $50 for each one of these cats, and of course, I'm not getting a dime. So they're actually, as far as I'm concerned, it's paid for. You know what I'm saying?
Okay. Well, that may not be how they see it, but is there?
Yeah, I would like to say, if she decides that she doesn't want to sign this at all, like even if I, I'm gonna try to negotiate with my mother and get her to sign this. But if she doesn't, is it possible for me to sign it for her? Because I take care of her financial affairs.
Counsel.
Do I need to? Because I don't want her to have to go through.
Do you have a power of attorney to take care of her financial affairs?
I didn't. I was supposed to get that filled out, and I never got it filled out.
Okay. So, I mean, I think technically the correct answer is that if you had the power of an attorney over her financial affairs, the court could deem this a financial affairs issue.
Okay.
But without that, I don't think you can just make that decision, even though it may be the best decision. I don't think you can do that.
I'm trying to make the best decision for her, because I don't want her to go through having to pay for so much that she can't afford.
Right, I understand.
That's a stray.
Yeah, if she is not comfortable signing that, the other option is to not claim ownership of the cat at all, and then the court would forfeit the cat, and whatever resolution happens in this case happens. So.
Is that an option to not? You don't want to claim? Does that have to be done by Ms. Saeed also?
Correct.
Okay, so she can either sign or not claim ownership.
Correct. She can say, I'm not the owner of the cat and leave.
And Ms. Saeed, I know with I'm not sure with this one, and I don't want to put words in your mouth, but I know when we were here before, one of the cats had just recently come to you, so I don't know. So maybe there is no problem with not having ownership in the cat that you hadn't had for very long prior to this occurring. So I don't know. Those are the options. I'm just trying to conclude this hearing right now with being respectful to everyone involved.
It's just a situation so abrupt, and of course, it got me extremely upset because they come out of nowhere. They come out of nowhere, and then they just disrupt my life like that. I'm just trying to. I'm just trying to.
So what I'll do is this. Let me do this. I'm gonna give it, maybe 10 minutes or so. because we still have other professionals in the room. Let me try to give them the courtesy of moving their cases, and maybe we can resolve this. I don't know if there's more conversation that can happen in the hallway, or maybe you can speak with your mom, and we can just have a seat and I'll recall it and see where we are at the very end. Thank you.
Can we do Urban Mitchell? There's a lady with a baby out there. She's been out there most of the morning.
Okay. Yeah, Mitchell.
Mitchell, I'm sorry.
All right, Mitchell Irwin, I'm sorry. 21 CRB 00412 from April 25th, alleging of domestic violence. Domestic violence is a first-degree misdemeanor, which means you could get up to a $1,000 fine and 6 months in jail. Just as important is that if you are charged with a domestic violence and you plead to it, or you're found guilty, the next time it's charged as a felony, and it continues to go up in charges every time you are charged with this particular case. This was where they're saying that you did knowingly cause physical harm to Laura Williams by pushing her and spitting on her and also making threats. So this was charged, I think, as both of M1 and an M4, or is it?
As far as I know, there was only the one charge. I'm not sure.
Okay.
I haven't seen the, so I don't know whether they charged as no one.
Mr. Irwin, how long have you been in jail? I'm sorry, Madam Prosecutor.
Since Saturday.
All right, Madam Prosecutor.
Yes, the victim in this matter, Laura Williams, is present, and she's executed a refusal to assist, which frankly, after reading the report, I wasn't surprised. The whole incident seemed minor in the beginning, and it's mostly him coming home intoxicated to get a little out of pocket with everybody that was present. So in light of the relatively minor nature of the report and the refusal to assist, I was going to offer a minor misdemeanor.
Okay, I'm going to hear from counsel, but I'm also going to hear from Ms. Johnson. Is there a particular order you want to speak now?
Your Honor, at this time, after talking to my client, he'll plead no contest to the charge as amended. Disorderly conduct, minor misdemeanor. As part and parcel of that plea, any additional count would be dismissed. We'll waive reading of the facts, Your Honor.
All right, Ms. Johnson, is there anything additional you'd like to add for the record? All right, so Mr. Irwin, and ma'am, you want this to be reduced?
Mhm.
All right, so a minor misdemeanor means you're not going to have any jail time, and the maximum fine is $150. You understand that? You have to say yes or no.
Yes.
How do you plead to that charge?
Um,
The minor misdemeanor, how do you plead to that?
yes.
All right, and you're 39?
Yes.
All right, so the small speech I'm gonna give you, you already know, because you know I normally have, well, not normally, I mean, this, what I'm gonna say, I would expect it to be a lot younger, but you know they're alleging that you spit on her, right? And whether you were intoxicated or not, you know that's not the right thing to do. Is that your child?
Yes.
Okay, so I mean, I try to give individuals visualization. I mean, I know you love your child, I mean, as in any man should, but imagine your child getting older and spitting on you or spitting on mom. You wouldn't go for that. You know what I mean? The same applies to us. You know, you can't treat her that way, no matter how upset you are, no matter how intoxicated you are. There are certain lines that you just can't cross. And you sat in jail for 5 days for that, you know? And honestly, had this not been reduced, you could be sitting in jail for 6 months for that. And it's never worth that, right? There's no argument worth that type of jail time. And you definitely don't even want to take it to the level where there's physical harm. All right. So I'm gonna accept the fact that everyone is on board with this resolution and your no contest plea. It'll be a $150 fine plus cost, and you'll be released from jail. Any questions, sir? All right, you can have a seat. And Mr. Irwin, I don't recall seeing you before, but I really have, just so you know, between you and I have a real hard time reducing domestic violence. So, you know, don't prove me wrong. You know what I'm saying? Don't, you know, I'm accepting what they're saying, but even with all what they're saying, it's difficult for me. So I'm looking out for you. So don't let this come back and bite me. All right. Zachary Trigg. Mr. Trigg, how long have you been in jail? So last night? Last Wednesday, okay. So you're here on 21 CRB 00406, possession of drugs and consumption of alcohol in a motor vehicle. April 22nd. 21 TRD 02195, no driver's license and a seatbelt. And then 21 CRB 00418, drug controlled substance or criminal tools. And it looks like, counsel, we're resolving these cases today, all of them?
That's correct, Your Honor.
All right, so as I flip through here, it looks like your attorney and the city prosecutor has agreed to minor misdemeanors on both of these cases involving the drug abuse and or drug instrument. So with that being said, I'm gonna hear from the prosecutor on both of those reductions and we'll go from there.
Yeah, they're both marijuana charges, so generally this will be more of a minor misdemeanor anyway.
All right. So to the minor misdemeanor in 21 CRB 00418, how do you plead? All right. I'll accept that plea with a fine of guilt. It'll be a $50 fine plus cost. In 21 CRB 00406 to the minor misdemeanor, how do you plead? All right, $50 on that. And just so you know, on that other charge, consumption of alcohol in a motor vehicle, that's like a step away from an OVI, but obviously they didn't think that you were under the influence. So be careful with that because the OVIs have penalties that just never seem to stop. It gets really crazy. Counsel?
Passenger in the vehicle, Your Honor.
Passenger, great. All right. So then we have 21 TRD 02195 from April 22nd, no driver's license, but you were a passenger. You didn't have a seatbelt. Same date? Was this the same date?
I was driving.
You were driving at this point. Okay. How do you plead to the no driver's license? All right. It'll be a $200 fine plus costs. You won't be in jail for that. The second charge will be dismissed. So you will be released from jail today. Just be careful going forward. All right. You're welcome. Yes. Can I give you a cheer? No, you're not on your way back. I know you're trying. I know. I know that's a challenging one. I'm familiar with. It's just with anything, it's challenging.
I'm sure you remember the last one. So
Yes.
if,
And that's with every other type. Thank you. All right. Alvin Bradley. Mr. Bradley, 21 CRB 00411. This is from April 24th, alleging that you carried a concealed weapon, resisted arrest, and committed disorderly conduct. Sir, you spoke with the defense attorney, correct?
Yes, sir.
The concealed weapon is that you had multiple large blades on you on or about April 25th. The disorderly conduct is engaging in a physical altercation at the Shell gas station on April 25th, and then failing to comply with officers' orders resulted in the resisting arrest. And you're 41 and you're entering a plea of not guilty this time, correct? And again, how long have you been in jail? And do you stay in the city of East Cleveland? So you understand if I let you out of jail, you're required to come back to court for one, right?
Yes, sir.
And then also, I don't want you at the Shell gas station getting in any arguments or fights. That's one of the other requirements. You understand that? All right. And keep in mind, you could get up to a $1,000 fine and 6 months in jail on all these. So they're very serious. Okay. So we're going to plead not guilty this time. Is there an objection to a personal bond for Mr. Bradley?
Yeah.
So it'll be a $10,000 personal bond. That means I'm letting you out based on you giving me your word that you'll be back on May 17th at 9:30 and that you will not get in any trouble while you're out, okay? All right, we'll see you back on May 17th. Pierre Rhodes. Mr. Rhodes, we have two cases, 17 CRB 00831 back from June 26, alleging that you had induced a panic with a possible bomb threat, but we're maintaining not guilty on that. But then we have 21 CRB 00423, which is alleging that on April 26th, that you were involved with an assault to the extent where they're saying that you did punch another man in the ribs and the face. All right, and you've been in jail for how long?
I believe I got here Tuesday, Wednesday, Thursday.
Yep.
It was Tuesday, so 2 days, so 2 to 3 days.
And where do you live? What city?
Cleveland.
So you understand any bond that I set would require you to have no contact with the alleged victim, right?
I don't even know it.
All right.
Why would I hit him?
Okay.
I mean, it's kind of hard to explain.
But you, all right, you don't have to right now, because your counsel wouldn't want you to, but would you know him if you saw him? All right, yeah. All right, because I was gonna say, if you see him, based on me letting you out on a personal bond, I want you to go the opposite direction so that you don't have any issues. If you walk into a store, that person's there, go the opposite direction, all right? No contact right now. Let's find out what's going on. Let's get the case resolved. And I'm gonna have you come back on May 20th, all right? May 20th, which is, a little ways away, so don't let yourself get caught up in any issues with this person or anyone else. May 20th at 9:30. I'll see you back then. All right. And I think that's it. All right, counsel, thank you very much. I guess, can you, on your way out, can you see if, yeah. Detective, thank you so much for your work. Appreciate you. Yeah. With everything, like she's pretty difficult with everything. Yeah. All right. Hmm?
Most of this stuff that happened in 2000.
That's a good question. So there should be a statute of limitations. That's why I set all of the criminal cases on your docket, because you're the only one that will stand and make an argument for them. Right.
So I'm just,
It's a good
I
point.
have to do a little looking into that. Okay.
Okay. The last couple. I just don't understand. Like, it's so easy to take care of your animals if you're gonna have them. I mean, yeah, it's not. It don't require a lot.
Is there any way to get that to the city prosecutors?
Yeah, we have
And
it.
then I'll just, didn't do it, there's no evidence. I won't know.
Is she coming back in?
Great, thank you.
Or maybe not. Wait, is she coming back in? So we don't have any jails.